So let's continue our discussion on arraignment and plea under Rule 1016. So let us review briefly what is arraignment. Arraignment is the formal mode and manner of implementing the constitutional right of an accused to be informed of the nature and cause of accusation against him. So this definition was given by the Supreme Court in the case of People versus Pangilinan, 518 SCRA 358 March 14, 2007. So arraignment actually is the stage in the criminal proceeding wherein or when the right of the accused to be informed of the nature and the cause of accusation against him is exercised. So arraignment is an indispensable requirement of due process, just like what we said in our previous meeting. And since it is an indispensable requirement of due process, then it is mandatory. However, while arraignment is mandatory in criminal proceedings, it can still be waived by the accused. If the accused actively participates in the trial of his case, like for example, the accused even cross-examined the witness of the prosecution. So sabi ng rules ng Supreme Court in the case of People versus Demetrio Cabale na the act of the counsel or the act of the accused in participating in the trial in the criminal case or his active participation in the criminal case is a clear indication that the accused was yung word ng Supreme Court. It is a clear indication that the accused was fully aware of the charges against him. So since he actively participated in the trial, so the court or the Supreme Court presupposes that the accused was fully aware of the nature and cause of accusation against him. So there is no need to arraign him, to inform him, because by merely participating, it means that he understood the nature and cause of accusation against him. Kaya this right can be waived, just like any other rights of the accused. Take note that without a prior arraignment, the accused cannot invoke double jeopardy because one of the requirements or requisites of double jeopardy is arraignment. And the accused cannot also be tried in absentia if he is not arraigned. Okay. Take note that arraignment or this stage in the criminal proceeding is crucial because once the accused had already entered his plea, he will lose the right to avail of the remedies allowed by the rules of court before arraignment. So make sure that before you proceed to arraignment, if you are the counsel of the accused, you should make sure that you have already studied the case meticulously and carefully. There could be available remedies that you may avail before the arraignment. And I'm pretty sure that if there are grounds allowing you to avail of any of the remedies, I am sure that you don't want to lose these remedies. So therefore, before you go to arraignment or before you proceed to arraignment, make sure that you have studied already the case. Baka merong mga matters na pwede nating i-question bago ma-arraign si accused, okay? So what are the options that are available to the accused? Balikan natin, we said in our previous discussion that the accused can move for a bill of particulars, which means that if there are vagueness or if you want to clarify any matter in the complaint or information in order to enable you to prepare your defense, if you are the counsel, then you may move for a bill of particular. Then suspension of arraignment, we have 3 grounds for this. One is if the accused is suffering a mental from an unsound mental condition. The other one is if there exists a prejudicial question, remember the requisites. And lastly, if there is a petition for review of the resolution of the prosecutor, which is pending at either the Department of Justice or of the Office of the President. But take note here that the suspension is good only for 60 days. So hindi na pwedeng sumobra ng 60-day period. And remember the rule in preliminary investigation. Once the accused had already been arraigned prior to the filing of the petition for review of the resolution of the prosecutor, then the Secretary of Justice can no longer entertain the petition for review. Because when the accused was arraigned or when he entered his plea, the accused had deemed to have waived or abandoned his right to question the resolution of the prosecutor finding probable cause for his indictment. Okay, remember that. Then aside from that, you can also file a motion to quash under Rule 117. So we enumerated in our previous meeting the grounds for motion to quash. We said, di ba, na generally kapag hindi ka naka-raise ng any ground ng motion to quash under Rule 117, deemed waived na. So you can no longer raise that after arraignment and plea. But take note of the 4 exceptions to the rule. Ano yun? If the facts in the complaint or information do not constitute an offense. Second one, if the court lacks jurisdiction over the subject matter of the case, because the court can even motu proprio dismiss the case on that ground, based on that ground. Third, if the criminal liability had already been extinguished. And lastly, if there is double jeopardy. So remember the exceptions to the rule. Fourth, you can challenge the validity of the arrest or the legality of the warrant issued. But take note here that the purpose here is in order to question or to raise the issue on jurisdiction of the court. Because just like we said earlier, meron tayong principle na waiver of the illegality of the arrest does not constitute waiver of the inadmissibility of evidence procured from that illegal arrest. So hindi ibig sabihin na kapag nag-waive ka na to question the arrest, hindi ibig sabihin na waive na din yung right mo to question the admissibility of the evidence. Lastly, you can also challenge the regularity or question the absence of a preliminary investigation of the charge. So take note again, kapag hindi ka naka-challenge on time, on the ground that there is irregularity in the conduct of PI, or if you want to question the absence of PI, then waive na yung right mo to question it. Okay? So, again, arraignment under an amended information or substituted information, na-discuss na din natin to. Kapag substantial ang amendment, arraignment under the amended information is mandatory. And take note, ito ay, kasi arraignment na, di ba? Kasi kapag arraigned ka na, generally bawal talaga yung substantial amendment. But siguro, this rule presupposes that a substantial amendment was allowed by the court. Kasi that is discretionary on the part of the court, especially if the amendment is beneficial to the accused. So in such case, then arraignment is required under the amended information. But if the amendment is formal, hindi na necessary ang arraignment. Substitution naman, since you are charging an entirely different offense, arraignment is required. Ayan, paano ba ginagawa or kinakandak ang arraignment? Just like we said in our previous meeting, This is conducted in open court by the judge or clerk by furnishing the accused with a copy of the complaint or information, reading the same in the language or dialect known to him, and asking him whether he pleads guilty or not guilty. Okay? So take note here that the accused must be present, no, at the arraignment, and must personally enter his plea. So bawal yung arraignment by proxy. Okay? So, ano pa? Ito, ano yung mga grounds, no? Or ano yung mga instances wherein the court shall enter a plea of not guilty? We said in our previous meeting that a plea of not guilty shall be entered by the court if the accused refuses to plead guilty or not guilty. Or if he makes a conditional plea, like for example, sige, I will plead guilty to the offense provided you will impose a lesser penalty. So that is a conditional plea, and therefore the court is mandated to enter a plea of not guilty. Another is if the accused pleads guilty but presents exculpatory evidence, no? So his plea shall be deemed withdrawn and a plea of not guilty shall be entered for him. How arraignment and plea made, ayan, continuation. So ito yung period na kapag preventive detention, 10 days from the raffle. Pero normally, 30 days lang talaga, no? 30 days talaga yung period, no, within which the court should conduct an arraignment. And one important provision here is the provision about the presence of the private offended party. Required siya na mag-appear at the arraignment for purposes of 1, plea bargaining, 2, determination of civil liability, and 3, other matters requiring his presence. So, take note that in plea bargaining, isa sa mga requirement is yung consent ng private offended party. At kapag si private offended party fails to appear despite due notice at the arraignment, then the court may allow the accused to enter a plea of guilty to a lesser offense without the consent of the private offended party. So, conformity lang ng trial prosecutor ang kailangan kapag absent si private offended party. Ayan, napag-usapan na natin yan. Effect of plea of guilty, sabi natin in our previous meeting that generally kapag nag-plead guilty si accused, it is a judicial confession of guilt. Not just to the material facts alleged in the information, but also to the aggravating circumstances alleged therein. So kasali yung mga aggravating. And only material facts or mga facts lang, factual circumstances lang at aggravating circumstances lang ang deemed admitted. Hindi kasali yung mga conclusions of law. Okay? Okay, general rule yan siya, no? Kasali yung aggravating. But an exception to the rule is if the evidence disproves the presence of aggravating circumstances. Kung hindi siya proven by evidence and therefore the court shall not consider the aggravating circumstances in imposing the penalty to the accused. Plea of guilty to a lesser offense. Ayan, ang tawag natin dito is plea bargaining. So under section 2, plea of guilty to a lesser offense at arraignment, the accused with the consent of the offended party and the prosecutor may be allowed by the trial court to plead guilty to a lesser offense which is necessarily included in the offense charge. Okay? So, take note of the requisites here. Number 1 is that the plea must be with the consent of both the offended party and the prosecutor. However, subject to the exception that if the private offended party fails to attend or to appear at the arraignment despite due notice, then his consent or his or her consent may be dispensed with by the court. So, hindi na kailangan. So, pwedeng wala ng consent. Sa prosecutor na lang. And second requisite is that the plea of guilty or the plea bargaining must be to a lesser offense, which is necessarily included in the offense charge. Take note that you cannot plead guilty to a lesser offense which is not necessarily included in the offense charge. So dapat, paano mo ba malalaman na ang isang offense is necessarily included in the offense charge? Kapag ang elements ng offense na yan is or are also the elements of the original charge. Okay? Example is, qualified theft and theft. Simple theft. So from qualified theft, pwede kang mag-plead guilty to a simple theft. Kasi yung elements ng theft, di ba, unlawful taking of a property belonging to another with, ano ba yung next na elements niyan? Intent to gain, di ba? And ano ba yung elements ng theft?
Without force.
Without force.
Things,
Okay, so basta ko, remember nyo lang yung elements ng theft ha. Yung sabi dyan, yung elements niya, elements din ng qualified theft. Kaya lang, sa qualified theft, may additional element, no? Ang isang example niyan is yung abuse, remember? Ano nga yun?
Subconfidence.
Ha?
Use
Abuse
of
of
confidence.
confidence, right? Yun siya. So, or if domestic helper yung nagnakaw, di ba? So, meron siyang additional element. Kaya, the simple theft was parang na-raise siya or na elevate siya to a qualified theft. So, yun siya, no? Dapat, the lesser offense must be necessarily included in the offense charge. So, what if, for example, the original charge is qualified theft and now you will plead guilty to the crime of ano yung natin, like ano nga yung kapag sinira mo yung bagay na walang walang dahilan. Yes, malicious mischief, di ba? So, you cannot plead guilty to malicious mischief, no, from qualified theft because these two offenses have a different elements. So, dili pwede, no? Dapat, yung lesser offense must have the elements of the offense charge. Okay? So, I hope you got it, no? The phrase necessarily included in the offense charge. Ayan. So this means that you cannot just plead guilty to any offense, any lesser offense. No, hindi pwede yun siya. Dapat merong connection yung offense charge tsaka yung offense na ipiplead guilty ng accused. Okay? So next sentence, after arraignment, but before trial, the accused may still be allowed to plead guilty to a lesser offense after withdrawing his plea of not guilty. No amendment of the complaint or information is necessary. Okay. Itong second sentence, ang ibig sabihin lang nito is kailan daw pwedeng mag-plea bargain si accused, di ba? Generally, hindi pala siya generally. The accused can plea bargain in first at arraignment, no? So, during arraignment, pwedeng mag-plea bargain si accused. So, instead of entering a plea of guilty or not guilty to the offense charge, pwedeng diretso na hindi na siya mag-arraign doon sa offense charge kapag nag-apply na siya for plea bargaining at na-approve na ng prosecutor at ng court, then automatically he may plead guilty to the lesser offense. Second is, kung tapos na yung arraignment, then the accused may also apply for plea bargaining during the pre-trial of the case. Kasi one of the matters that is discussed or taken up in pre-trial is the possibility of entering into plea bargain. So plea bargaining, no? So pwedeng sa pre-trial mag-apply si accused ng plea bargaining. So tapos na yung arraignment, di ba? So plea bargaining siya at the pre-trial stage. So ano ang mangyayari kapag na-allow si accused mag-plea bargain during pre-trial? Then his prior plea of not guilty will be withdrawn, and a plea of guilty to a lesser offense will be entered, no, at the pre-trial stage. But if, for example, na-terminate na yung pre-trial without the accused entering into plea bargaining, pwede pa rin siyang mag-enter into plea bargain even after the prosecution had rested its case. So kahit pala tapos na si prosecutor mag-present ng lahat ng evidence niya and witnesses niya, pwede pa rin mag-apply si accused ng plea bargaining. Okay? Kasi sabi dito sa ating provision, after arraignment but before trial, the accused may still be allowed. That is pre-trial. Pero under the rules, ito, in the case of Daan versus Sandigan Bayan, GR numbers 163972277, decided on March 28, 2008. Sabi dito, it has been held, however, that it may also be considered during the trial proper, and even after the prosecution has finished presenting its evidence and rested its case. It is immaterial that plea bargaining was not made during the pre-trial stage, or that it was made only after the prosecution already presented several witnesses. So, pwede pa rin siya kahit na tapos na si prosecutor mag-present ng kanyang evidence. But take note that plea bargaining is not always a ready option for the accused. So hindi pwedeng anytime na gustuhin ni accused, pwede siyang mag-plea bargain, di ba? If, for example, the evidence of the prosecution is so strong, no, or it can prove the guilt of the accused, then the court may deny the application of plea bargaining. So sometimes plea bargaining is considered by the court kapag mahina yung evidence ng prosecution. Mahina ang evidence nila pero there is a parang talagang si accused talaga yung nag-commit ng crime. Kaya lang, they cannot convict the accused because the evidence is not that strong, no, to prove the guilt of the accused, or it cannot, or the prosecutor cannot discharge, no, the burden of proving the guilt of the accused, and so the court allows plea bargaining. Okay, pero hindi ito ready option for the accused na anytime pwede niyang i-avail. Take note that this is subject to the approval of the court, and this requires the consent of the offended party and the prosecutor. Okay? Let's go to the next slide. Plea of guilty to a capital offense. Ayan. So here, what you should remember here is that even if the accused had already pleaded guilty to the capital offense, the court is not allowed to render automatically a judgment of conviction. What is the reason behind that rule? It is clearly provided under Section 3 of the Rules of Court, Rule 116 of the Rules of Court, which says that the court shall conduct a searching inquiry into the voluntariness and full comprehension of the consequences of his plea, and require the prosecution to prove his guilt and the precise degree of culpability. Okay? So, meaning to say, even if the accused had already entered a plea of not of guilty to a capital offense, the court should conduct or perform the following acts. Number one, conduct searching inquiry. What is the purpose of the searching inquiry? The court should make sure that the accused pleaded guilty to a capital offense voluntarily. Dapat voluntary on his own accord. And that he had full comprehension of the consequences of his plea. Dapat ma-make sure ni court na alam talaga ni accused kung ano yung consequence ng kanyang plea of guilty. So let me relate to you a case, no? In one case, the accused pleaded guilty to a capital offense. Pero, during the presentation of the evidence of the prosecution, the accused, during the presentation of the evidence of the accused repeatedly denied the commission of the offense. So, if you can just compare, no? Ano ba talaga yung totoo, di ba? Akala ko ba nag-plead guilty ka na to the offense? And why is it now that you are denying that you did not denying the commission of that offense, di ba? Yung kamakailan lang at the arraignment, sabi mo guilty ka, tapos ngayon nung nag-take ka na ng witness stand, sabi mo hindi mo ginawa yun siya. So it could be that the accused had no full comprehension of the consequences of his plea. So pwedeng hindi niya naintindihan kung ano yung consequence ng plea niya. Baka akala niya, ano lang yun, para ma-lessen or ma-mitigate yung kanyang penalty, di ba? So that is what is required, no? From the court, or what is mandated, no, for the court to perform before rendering a judgment of conviction. That is the purpose of searching inquiry. Second one is that the court is mandated to require the prosecution to present evidence para i-prove yung guilt ni accused at ang precise degree of his culpability. Third, to ask the accused if he wishes to present evidence and allow him to present evidence if he so desires. So take note of the guidelines in conducting a searching inquiry. Number one, the court should ascertain from the accused himself. So pwedeng itanong ng court how he was brought into the custody of the law, or whether he had the assistance of a competent counsel during custodial and preliminary investigations, or under what conditions he was detained and interrogated during the investigations. Second, ask the defense counsel a series of questions as to whether he had conferred with and completely explained to the accused the meaning and consequences of a plea of guilty. Third, elicit information about the personality profile of the accused, age, socioeconomic status, and educational background. Baka walang natapos si accused, hindi siya nakapag-aral, and now he is pleading guilty to a capital offense. So it could be a basis for the court, no, of inquiring whether or not meron talagang full comprehension si accused, no, sa consequences ng kanyang plea. Inform the accused the exact length of imprisonment or nature of the penalty under the law and the certainty that he will serve such sentence. And take note that it is not enough that the court should only tell the accused that the penalty is death penalty. Hindi enough na i-inform mo lang siya na ang penalty nito is death penalty. Dapat the court should conduct all of this, no, enumerated. These matters, no, included in the guidelines, no, in conducting a searching inquiry. Kailangan ginawa ito lahat ng court, hindi lang isa lang dyan, no, dapat yan lahat. Inquire if the accused knows the crime with which he is charged and fully explain to him the elements of the crime which is the basis of the indictment. Then, all questions should be in a language known and understood by the accused, and satisfy himself that the accused in pleading guilty is truly guilty. That is why the court should require the prosecution to present evidence to prove the guilt of the accused. So, hindi enough yung plead guilty niya. kailangan ma-prove din talaga na guilty si accused, no, based on the evidence of the prosecution. So, ang requirement lang is that the court should satisfy himself, no? So, pwedeng hindi proof beyond reasonable doubt, no? Para maano lang niya, based on moral conscience, na maisip niya na guilty talaga ito siya. Okay? So that is what we mean by satisfying himself that the accused in pleading guilty is truly guilty. So take note of the guidelines, no? Next, improvident plea of guilty. So itong improvident plea of guilty, this happens if the court fails to observe or to comply with the guidelines in conducting the searching inquiry. Kapag hindi niya na-comply yung guidelines, then ang effect nun is yung plea of guilty ni accused is an improvident plea of guilty. So ano ang mangyayari kapag may improvident plea of guilty? Under Section 5, at any time before the judgment of conviction becomes final, the court may permit an improvident plea of guilty to be withdrawn and be substituted by a plea of not guilty. So pwedeng ang defense counsel, pwede niyang i-move, no, yung withdrawal ng improvident plea of guilty. Kapag, for example, it can be proven that the accused did not understand the consequences of his plea, no, or that if the court finds that the accused was forced into entering a plea of guilty, so pwede na a proper party may move for the withdrawal of the improvident plea of guilty. Okay? However, there is an exception to this rule. So sabi ng court, in the case of People versus Talusan, while the court has set aside convictions based on improvident pleas of guilty in capital offenses, which pleas had been the sole basis of the judgment, where the trial court receives evidence to determine precisely whether the accused erred in admitting his guilt, the manner in which the plea made loses significance if the conviction is independently of the plea based on the evidence proving the commission by the accused of the offense charge. Ayan. So, ibig sabihin lang yan, while it is true that the court may permit an improvident plea of guilty to be withdrawn, pero if, for example, there is an evidence that would sufficiently prove the guilt of the accused independent of such improvident plea, then the court may not allow the withdrawal of the improvident plea. Okay? So, pwedeng hindi niya i-allow kasi meron namang evidence. Ang pwede lang i-allow ng court na i-withdraw yung improvident plea is if the judgment of conviction is based solely on such improvident plea of guilty. Kapag yun lang ang basis talaga ng court in rendering a judgment of conviction, then the court may permit its withdrawal. Pero kapag merong independent evidence or evidence independent of the improvident plea of guilty, then that improvident plea of guilty loses legal significance. And therefore, the court may not permit the withdrawal of such improvident plea. Okay? So kahit na improvident siya. So it would be, sabi ng court, useless na para i-withdraw natin yan. Kasi klaro naman sa evidence that you are guilty. Okay? Now, plea of guilty to a non-capital offense, here, the court is not required to determine, no, through the reception of evidence, no, the guilt of the accused and the penalty to be imposed. So it means that the court's parang order for the reception of evidence may be discretionary in nature. So you cannot demand that the prosecution should present evidence first, no, before rendering a judgment of conviction, because that requirement or that reception of evidence is merely discretionary if the offense is a non-capital offense. So the court may immediately render a judgment of conviction if the plea of guilty is to a non-capital offense. Okay, that ends our discussion for arraignment and plea. Okay, do you have